And of course, let me just put up what we're doing a little bit on the symposium, and then it's all about you and the topic, which is of course mediation legislation. So let me give you 1 second to put it up.
Excuse me.
Yeah,
Vikram, just one second.
Yeah, I'll just talk about the symposium, basically mediation legislation, the how, what, when, where, which, who, why of it. And of course, Catherine will tell us about herself. Parvati is what we call her. So that's what about the symposium. And Parvati, if you want to, yes, a little bit about yourself. And if you want me, if you think you have time, I can talk about where to find information about me. If you don't have time, we'll skip that. So totally up to you.
Okay, 2 words about me. I'm a mediator, mediator's trainer. I'm a member of the Central Commission of the Ministry of Mediation of the Ministry of Justice. I'm also a coach, a life coach, certified recently by the University of Athens. And I am the chair of the Hellenic Union of Mediators, founded in 2010. Since then I am the chair, and I continue. I do not know for how long I will continue, but I'm still. I'm very pleased to have the opportunity to present today the legislation of mediation on mediation in force in Greece, because to my opinion, there are some issues very interesting which are dealt with by the new law. And I will give you some background regarding mediation and ADR in general.
Perfect. Thank you very much. And of course, the Hellenic Union of Mediators and I did jointly organize the Symposium on Philosophy and Mediation, which was, of course, a very interesting symposium. And of course, there was, I mean, we had, I don't know how many people we had, but it was really, I mean, I think what came out was quite interesting, that mediators are philosophers in practice and mediation is philosophy in practice. That was the interesting thing that came up. So basically, information on mediatorvikram.com. I mean, basically, it's like a notice board of information. This is the new series, which is Magic in Mediation. And of course, connecting all World Mediation Circle. Please read about that, and we'll work on that. Otherwise, everything is here, so I won't take your time. So it's all yours, mediation legislation. Please, Parvati.
Thank you very much, Vikram. I'm very pleased to be with you again today. It is the 3rd time that I am honored by an invitation to make a presentation. Thank you so much. And I will start by saying that mediation, we will speak about mediation. To my opinion, everybody should be aware of what is mediation, because it is very well known since ever, if I may say so. But I have the occasion, because I'm also a member of the commission for the exams of mediators, for them to be recorded with the registry of the Ministry of Justice. And I notice often that young people are not very well informed about mediation and the purposes of mediation, especially. So let us make one step backwards just to say that mediation is not new. As I had the opportunity to expose during the presentation I have done in the Symposium, Mediation and Philosophy, mediation was known to all ancient people. Mediation in the sense of the intention and the action towards a friendly resolution of disputes, often with the support of a third person. The third person is today the mediator. Then it was not called the mediator, but his role was the same. This is why, because of the support of a third person, this is why mediation is often called a facilitated negotiation, because as a matter of fact, it is that. However, mediators should not commit the error to interfere and in one way or another to dictate solutions to the participants. Let us see now what happened in the present, now, at present, in the modern times, which has given birth to mediation. In the 60s, both in the United States of America and also in Europe, an overloading of the courts was noticed. And this was the reason, having dictated to the authorities to find ways or to encourage people to find ways for a resolution of their disputes in other ways than legal proceedings. They have called these other ways alternative dispute resolutions, which is not very appropriate, because when we say alternative dispute resolution methods, there is somehow a meaning of less importance, that these methods are less important than the legal proceedings, which is not true. This is why many well-known internationally mediators reject this word alternative and prefer to say different ways of mediation, of dispute resolution. In French, it is called, in English, it is ADR methods. In French, it is moyen alternatif de résolution des conflits, MARC in French. It is easy to remember, MARC being a name, so we can remember it. However, it has been emphasized since the beginning that these other means of resolution of disputes should not obstruct the right of the people to have recourse to legal proceedings, to have recourse to the court. This right is set forth both by the Convention of 1950 on Human Rights and the EU Charter of 2000 regarding fundamental rights, which was put into force in 2009 as part of a convention put in force in Lisbon. Article 47 of the Charter provides that every person has the right to have his case heard in a public hearing in a fair way and by a court duly set up and independent from any other authority. While Article 39 of the Convention on Human Rights provides that the disputes brought before the Court of Human Rights may be settled amicably. The important point to underline here is that the authorities of EU accept that these other methods of resolution of disputes are equivalent to legal proceedings. The basic action towards ADR, let us continue using the term ADR, the acronym ADR, because we are all accustomed to it. So the basic action was the resolution of the European Council issued during a meeting held on October 15 and 16 in Tampere of Finland, by means of which the Council invited the state members to develop out-of-court processes aiming to facilitate the recourse to justice this was the first time, the very first time, where settlement methods were searched, not referring only to consumer disputes. It was the very first time where reference was done to all disputes in general. In April 19, 2002, the European Commission submitted the final text of Green Paper regarding ADR applying to civil and commercial disputes. 8 years later, in August 20 of 2010, the European Commission issued a press release requesting the use of mediation. It was the first time mediation was specifically referred to, and not all ADR methods in general. So, requesting the use of mediation in order to save time and money in transborder disputes. Needless to say, that if mediation fails, the way to the courts is always available, of course. On May 21st, 2008, so before the press release, the European Parliament and the European Council had issued Directive number 2008-52 on certain aspects on mediation in civil and commercial disputes, imposing for the first time to the state members of the EU to include mediation in their respective legislation by May 21st, 2011 at the latest, meaning 3 years exactly after the directive was promulgated. It was provided in the directive that in case any state had already dispositions in its legislation governing mediation, it could keep them in force, provided they would be in line with the dispositions of the directive. Otherwise, they had to put them in line in case there were discrepancies. I would like to say very briefly, because I said it already in a previous presentation, that when the directive was issued, many countries had already set up special legislation in respect to mediation based on a model law known as Model Law on International Commercial Conciliation, elaborated in 2002 by the United Nations Commission for International Trade Law, UNCITRAL, which was modified in 2018. And it is called now the UNCITRAL Model Law on International Commercial Mediation and International Settlement Agreements resulting from mediation. UNCITRAL allowed the states to provide in their national legislations that its dispositions would apply not only to transborder, but also to domestic disputes. This is also the case of the European Directive. I must say that the European Directive is applicable to all the states of the EU except Denmark. In Greece, mediation was introduced by means of Law 3898 of 2010, promulgated in compliance with the above European Directive. Later on, Law 4512 of 2018 provided in the frame of its articles 178 to 2006 dispositions regulating mediation in civil and commercial matters and abolished the previous law 3898 of 2010. Thereafter, law 4640 of 2019 was put into force, abolishing any previous laws on mediation. The main dispositions of the law will be commented briefly and, when needed, compared to the corresponding dispositions of the European directive. Before going further, I must say that all the Greek laws I have mentioned provide that their dispositions are applicable not only to transborder disputes, but also to domestic disputes. Now, I have one question which I have put to myself very early, at the very beginning, when mediation appeared as a new notion. I asked myself by saying, why do we need mediation? In Greece, for instance, we have many articles in the Greek Code of Civil Procedure, in the Greek Civil Code, which allow the parties in dispute to solve their dispute by compromise, by talking together and find a solution out of court before they instigate legal proceedings. These articles are very detailed and they allow, and very frankly speaking, each time I have the opportunity to read them again, I can see no difference with mediation except the fact of the absence of the mediator. This is very important, of course, because the parties may speak together, fight, fly, stay, find a solution, but definitely, and I think that nobody will contest this, it is much easier if you have a third party which is impartial and which tries in good faith to help you to see what is your real interest, what is your watna, what is your batna, and lead you without dictating you any solution, lead you towards the amicable solution of the dispute, which has one additional and very important advantage, which is that it allows the parties to continue, if they wish, their good relationship, professional, friendly, or otherwise. Because mediation is a tool which is useful in all disputes of any kind, even in our day-to-day life. Without calling it mediation, in our family, when we have disputes and there is somebody who is wiser, more calm, more having more skills than us, when such a person helps, the dispute might be solved. Otherwise, we can end to a divorce or to a dispute which remains forever. So let us see now the main dispositions of Directive 2008 of 52 and those of Article of Law, 4640 of 19. Article 1 provides that the directive aims to facilitate the access to alternative dispute resolution methods and the promotion of the amicable settlement of disputes and the encouragement of the recourse to mediation specifically. The corresponding Article 1 of the Greek law provides that its aim is to regulate mediation and harmonize further Greek legislation to the above European directive. Paragraph 2 of Article 1 of the directive sets forth that the prerequisite for mediation to be applied to civil and commercial transborder disputes consists of the authority of the parties to make relevant decisions based on the applicable law. This rule, as a matter of fact, sets forth the same principle governing mediation in the frame of Greek law, which is that for a dispute to rank for mediation, the parties must have the right to dispose freely of its object. This is a must. I will give an example. For instance, assume that there is a testament, a will, which is considered by one of the heirs or the potential heirs as being illegal. This cannot be submitted to mediation. This dispute cannot be submitted to mediation because the parties cannot dispose freely of this matter. If it is illegal, it is something which cannot be solved by the agreement of the parties, but only by a court judgment. The same applies to divorce. Family disputes are the main disputes which are solved by mediation, yet there are matters which are excluded. As I said before, divorce cannot be solved by mediation. Neither other matters such as the adoption of a child, the resolution of such an adoption because it is not compatible to the law, etc. So the right to dispose freely of the object of the dispute is a must. The European directive provides expressly which are the disputes which cannot be referred to mediation, and these are the fiscal disputes, the custom and administrative dispute, as well as those having as object the responsibility of the state due to acts or omissions of it when it exercises its public authority. Acta iure imperi. I'm strongly convinced that this approach of the European directive is the most suitable. On the contrary, Greek legislation does not limit the exclusion of disputes arising out of acts or omissions of the state when they accrue out from acts iure imperi, but in general. The Greek law provides that the disputes resulting from acts of the state or of municipalities or communities or legal entities governed by public law, these disputes are excluded from mediation without making any distinction of the power in which they have been done by the state. This means that also acts done by the state and the other entities I mentioned before, during their exercise of iure gestionis, are excluded from mediation. To my opinion, this is not accurate because, for instance, assume that the state makes an agreement for supply of goods with one or more companies, and disputes arise out of this agreement. Why should these disputes be excluded from mediation? I believe that the way in which the directive governs this matter is more appropriate, and possibly after X number of years, the law will change to provide the same. The Greek law will change to provide the same. Let's go now to the definitions. All over the world, mediation, the definition of mediation and the mediator is almost the same. Mediation is a structured process, regardless to its name, where two or more parties of a dispute try voluntarily to reach an agreement in respect to the resolution of the dispute with the help of a mediator. The same is provided, this is the definition given by the directive. The same is provided by the Greek law. A little bit different. The Greek law provides that mediation is a structured process, regardless to its name, with main characteristics, and this is very important, that Greek legislation from the very beginning, from its Article 2, mentions the characteristics of confidentiality and private independence, private determination, where two or more parties attempt voluntarily in good faith and with transactional honesty. Again, this is an advantage of Greek legislation because it sets forth from the beginning the characteristics of Greek legislation. To solve a dispute, they have with the help of a mediator. Both the directive and Greek legislation provide that the mediation about which we are speaking now includes any attempt done by a judge in order to help parties to solve their disputes, provided the judge have not been has not interfered in any other proceedings before the mediation, or he will not interfere after the mediation, provided he has not dealt with this dispute earlier, or he will not do earlier. This is considered to be a mediation. Usually, this kind of mediation is called judicial mediation. It is not the same as the mediation about which we are speaking, because the judges are not often educated as opposed to the mediators. As to the mediator, the term, the definition is that the mediator is any third person who is requested to undertake a mediation in an appropriate, efficient, and impartial way, irrespective of his denomination or his profession in the respective state member, and independently of the way in which he has been nominated or in the way he has undertaken to conduct the mediation in question. This is very important because let's look into the Greek law. Now it provides, there are no prerequisites as to the profession of the mediator, but the first law, 3898 of 2010, provided that the mediator should be a lawyer. The European Commission has found that this was contrary to not only to the directive on mediation, but also contrary to the dispositions of other directives providing the free circulation of people in the European Union and the free exercise of professions under conditions of course, but not conditions not related to the profession of the person. So Greece, thereafter, in 2014, has modified Law 3898, abolishing this prerequisite, and now the only prerequisite is that the mediator must be a person educated in a university level and educated regarding mediation following programs of 80 hours. Now, I would like to say that just to make a parenthesis here, because I consider it important, that Greek law provides that the mediator, regarding the confidentiality, the mediator is bound not only regarding whatever takes place during the mediation, but also he cannot say or let others know, people out of the process know that a mediation takes place or is to take place or has taken place. Now let us see what is the definition or what is the meaning of transborder disputes.
Should we?
Transborder.
Can we just get Ashian in? Her session, actually, her time of a session has come in. You want to say hi to Ashian, and Ashian, you want to say hi to Catherine?
Hi, Catherine.
Hello.
Hello.
So, Parvati, do you think you want to just conclude so that we can get Ashian in? Yes, Catherine. Do you want
Vikram,
to
hear you?
Do you want to just a little conclusion kind of thing so that we can get Ashian in? Her session time has actually started.
I thought I had 1 hour at my disposition.
No, it was this symposium. It is 30 minutes. That then only we've been able to do so many sessions. Otherwise, it would. This time it's a 30-minute symposium. And Ashian actually, of course, could not finish. If there is more to do, Catherine, we can do another part 2 for you. So Ashian also, it's part 2. We can do a part 2 with you, maybe tomorrow sometime. We'll fix up a time.
Okay, another modification of the law, which Greece had to do, is to change the article which initially provided that for an institution to prepare, to instruct mediators, it should be constituted by at least one bar association in collaboration with one chamber of commerce. This was considered as contravening the dispositions of the European Union, and now the law in force provides that anybody, even a physical person, can be a trainer of mediators, provided it fulfills the dispositions of the law. Now, I would like to speak about, but it will take time, so I will not speak about the way.
We'll fix the time we can do tomorrow, because we have a workshop at 6:30 India time, which is now. Your session was at 6 o'clock. We can do a session with you tomorrow at 6 o'clock, same time as today. We could, if half an hour is enough, we can do a half an hour session tomorrow. Because of course there is lots that you have to. This is where the problem is. This 30-minute symposium is a problem, but look, to get more people in, it was something that I had to do. So tomorrow, let's do that tomorrow. We'll do part 2 tomorrow. Is that okay with you?
I'm not sure whether I'm available tomorrow.
Please make yourself available, Catherine. Please make yourself available. You have lots to contribute, and we have to have a discussion on how you look at what legislation should be like. One is, of course, what is there. but your view on the global perspective, the Greek perspective is also important. So let's do the same time tomorrow, the 6 o'clock that we did today. Let's do that tomorrow and we'll continue this.
I'm not sure at all, Vikram. I'll send you an email.
No, we'll do it. We'll do it. You'll 30 minutes is all I'm asking for. We'll do that.
I have 2 appointments tomorrow.
You're doing it for the mediation world. You're doing it for the mediation world. You need to do that for the mediation world. 30 minutes is all I'm asking. Not even saying 1 hour. We'll do 30 minutes and we'll take it from here. Right?
Okay.
Okay. We'll see you tomorrow. And of course, always a pleasure listening to you. I mean, would have kept longer sessions, but I said, let's get more people into the thing. So thank you very much. And we'll see you tomorrow then. Yep.